How you guys doing today? It's Anthony Ganji. Welcome to another episode of Tier Talk. Guys, today we're going to cover the Aaron Spencer case. Now, this has been out there for a while. I'm a little late to this one. I've been covering other things, but I do want to cover this because this incident where a father protects his daughter and a life is taken in the process, this could happen to any one of us. Any one of us could find ourselves in this position where we have to make that choice. And it's always going to be family over the person who could put my family in harm. Sometimes this is not even about the criminal justice system. It's about a father's justice and a way to protect his child in the moment. In the moment. This is a very unique story. It's got a lot of twists and turns. So I've been doing some research. I'm going to learn with you in the process because that's how we do it here. And hopefully some of the stuff we discuss here can lead for some good comments and discussion in the board. Because in the end, there's a lot here that needs to be looked into, a lot here that needs to really be reviewed. I mean, how do we get to a point where a father is being charged for second-degree murder for protecting his daughter? Now, again, there are many people that see his act as legit. This is what they would do. And there are some, unfortunately, who see this as him being a vigilante. I'll let you guys make that decision, but I'll tell you right off the bat, I'm with the father on this one. I am. But with that said, if you guys like the content, please, I do have a Buy Me a Coffee. I have the link to that in the description for this video, but also on the top of my page. And let me go ahead and play one video just to give us a little bit of a background. And then after that, we're going to go ahead and discuss it. There's a lot to discuss here.
If I told you a candidate for county sheriff chased another man down, ran his vehicle off the road, and then shot him dead in cold blood, would he get your vote? This is not a parlor game. This actually happened a year ago in Arkansas. On that night, Aaron Spencer was desperately looking for his 14-year-old daughter. Police said that she had been stalked repeatedly and raped at 13 by a 67-year-old man named Michael Fosler. And that night, his daughter was missing. When the girl's father spotted the suspect driving down a dirt road with his daughter in Fosler's front seat, he took off after him, understandably. That driver had more than 24 stalking and sex crime charges pending, involving both the child in his truck and another girl. Somehow, Michael Fosler was out and about that night because he was free on a mere $50,000 bond that he had no trouble posting, and it seems he had no trouble violating a no-contact order either. And so, police say, the girl's dad, Aaron Spencer, ran him off the road and shot him dead and got his daughter. That dad himself is now free on bond and campaigning. That's his campaign picture. He's campaigning to become the new sheriff, despite a looming second-degree murder trial this coming January. But in his video announcement, he says it is not about revenge against the sheriff who arrested him.
This campaign isn't about me. It's about every parent, every neighbor, every family who deserves to feel safe in their homes and safe in their community. It's about restoring trust, where neighbors know law enforcement is on their side, and families know that they will not be left alone in a moment of need.
So next March, this man, Aaron Spencer, is going to stand in the Republican primary for sheriff of Lonoke County in Arkansas. He threw his hat in the ring just last week. And while he has pleaded not guilty to the murder count, he's not exactly running away from what happened the night of October 8th, 2024. The incumbent sheriff, John Staley, tells News Nation, and I quote, "My motto has been and will continue to be, do what's right, not what's easy. Doing what's right isn't always popular." And I cannot wait to hear my next guest and her take on all of this, because Tarlika Nunes Navarro is a former judge. She's also a former prosecutor and criminal defense attorney who's now the dean of the St. Thomas University College of Law. Judge, so good to have you. What is your first impression of Aaron Spencer's case?
Actually, when you think it just can't get any weirder and weirder, every time I see you, we have another case that we're shocked at. It's just a man that is defending his daughter, goes out, finds his daughter in a truck with a sexual predator, rams him, shoots him, kills him, is on trial for murder, will be tried in January, and at the same time is running for sheriff. It's almost mind-blowing. And as a defense attorney, it's crazy, because when I put my defense attorney hat on and I think about, possible venue relocation, this is not good for him, because, the community is going to know him. They're going to recognize him. The voir dire is going to last longer. You're not going to find jurors who are going to be unbiased. And it's going to be good for the prosecution when their case is moved to another venue. So as a defense attorney, this is not a good idea.
Well, so I'm looking ahead to that trial. And if there were ever a trial where I could, in the crystal ball, see a case for jury nullification, it's this one. And for those who are new to this program or new to true crime, jury nullification is when a jury looks at the guy and says, yeah, he did it, but I ain't going to convict him. That's what I foresee likely happening in this case. And then I want to transfer that to the actual campaign, because if the notion out there is any parent would do the same thing, could this actually help him win? Like the campaign.
Of course. I mean, name recognition, getting out there, all of this, new defendants become micro celebrities. We're seeing more and more of it, just like your previous case with Luigi. We're seeing it time and time again. Of course, it's going to help his campaign, but is it going to help his murder charge? No, like I said. And jury nullification, judges don't like it. We don't like to talk about it. We don't like to encourage it. We have to have rule of law. We have to have accountability in our system. If we all go out there and we take the law into our own hands, it's going to cause a breakdown in our judicial system.
So quick last answer here, but I got to ask it. If he prevails as sheriff and he prevails in his murder case through a not guilty plea or jury nullification, if that's the case, what does that say about, implementing justice when he himself extrajudicially committed this murder allegedly now, but let's just sort of foresee that?
Well, if he is acquitted of this crime, then the system is essentially saying that he did not commit this crime, or the jury is saying, yes, the facts are there, but we are not going to commit him because we don't believe that the law should be upheld here. So then if that is the case, then the law is doing what the law is supposed to do. And the jurors, his peers, are acquitting him. And so he could realistically, yes, then run for sheriff, but then he would have to hold other people accountable. And if he's not really being held accountable for the crime that he has committed, can he really be a sheriff? And is that what we really want for our sheriffs? I don't know.
As much as you say judges hate to hear about jury nullification, I think a lot of our viewers are kind of like hoping for it in this case, because I can hear them. I can hear them all through the screen right now saying, I'd have done it. And I got to be honest with you, Judge, I think I would have done it too if that was my baby in that car. Thank you for having.
So, we're going to cover all this, but I just want to mention something. We all have rights. And sometimes what happens here is they're concerned that there'll be a precedence. And then eventually what happens later on down the line is that those rights get bastardized for a defense. And that's where I think we're in trouble a lot, just as a nation, is that we have rights, but then you get people that will bastardize those in their defense. But in this case here, it looks pretty cut and dry. I mean, obviously the evidence will speak, but no, sometimes you have to look at things case by case. All right, so let's talk about this case. So a father shooting and a battle over justice. So this is the night everything changed. So on October 8th, 2024, Aaron Spencer's 14-year-old daughter didn't come home. What began as a missing person call in rural Lonoke County, Arkansas, ended hours later with a roadside confrontation and a fatal shooting that would divide a community and ignite a national debate over where parental protection ends and vigilante justice begins. So what began as a missing person call in rural Lonoke County, Arkansas, ended hours later with a roadside confrontation and a fatal shooting that would divide a community and ignite a national debate over where parental protection ends and vigilante justice begins. Spencer, a 38-year-old Army veteran and father of 5, says he did what any parent would do. After reporting his daughter missing to local authorities, he used her phone location to track down a pickup truck he believed she was inside. Behind the wheel was 67-year-old Michael Fosler, a man Spencer knew all too well. Moments later, Fosler lay dead from a gunshot wound on a darkened stretch of Arkansas highway, and Spencer was in handcuffs. But this wasn't a random encounter with a stranger. Earlier that summer, Fosler had been criminally charged with internet stalking of a child and electronic facilitation of child sexual abuse, charges alleging he had groomed and exploited Spencer's daughter through online communications. Those charges were still pending. Fosler was out on bond, and the case was working its way through the court system when Spencer confronted him that October night. Spencer insists he acted only to save his daughter from immediate danger. Prosecutors are saying it was murder. He was arrested at the scene and later indicted by a Lonoke County grand jury for second-degree murder with firearm enhancement. He pleaded not guilty, arguing that under Arkansas law, he used lawful deadly force to protect his child from what he reasonably believed was imminent sexual assault. He reasonably believed it was imminent sexual assault, and can't fault him, right? I mean, look at the background of this guy. Look what they've been going through. Look what the family's been going through. So it made all the sense for him to believe that that could have happened or would be happening. So Aaron Spencer is a U.S. Army veteran who served his country before returning home to Lonoke County to build a quiet life. He and his wife, Heather, are deeply rooted in their community. Heather's active in their local church, and together they raised 5 children on the values of faith, hard work, and family. For years, their lives were unremarkable in the best sense. Friday night football games, church potlucks, county fairs, and the rhythms of rural Arkansas life. That all changed in early 2024 when their teenage daughter, then just 13 or 14 years old, became the target of an online predator. Sounds familiar. Sounds like we're also talking a little bit about the Celeste Rivas Hernandez case. According to court documents filed in Lonoke County, Michael Fosler, a 67-year-old man, began communicating with the girl through social media platforms. What started as seemingly innocent messages quickly escalated into what investigators will later describe as grooming, a calculated pattern of manipulation designed to build trust, break down boundaries, and ultimately facilitate sexual exploitation. When the Spencers discovered what was happening, they immediately contacted law enforcement. Investigators with the Lonoke County Sheriff's Office and Arkansas State Police launched an investigation. Digital forensic examiners combed through phones, tablets, and social media accounts. What they found was damning. Explicit messages, requests for images, and evidence of prolonged contact between Fosler and their minor child. So the very first time this was happening, they did the right thing. They called the police. They got the police involved. They go through the system, and they find out he's allowed to bond out with the protection of a no-contact order. And how many times have we seen those no-contact orders violated? So maybe the family felt that once he went through the initial case, and as we're waiting to go through trial, he just gets bonded out because it's only a $50,000 bail. Maybe they also start to lose a little trust in the system. Maybe. In July of 2024, prosecutors filed 2 felony charges against Fosler: internet stalking of a child and computer child pornography with electronic facilitation of child sexual abuse. These are serious charges. Under Arkansas law, internet stalking of a child involves using electronic communication to harass, intimidate, or contact a minor in a sexually explicit manner. Electronic facilitation involves using a computer or device to compile, transmit, or possess sexually explicit material involving a child or to facilitate sexual contact with a child. Fosler was arrested, arraigned, and released on bond pending trial. It was like a $50,000 bond, we heard. His case was actively moving through the Lonoke County Circuit Court. For the Spencers, the arrest felt like justice finally taken hold. Their daughter was safe. The predator was identified, charged, and would face trial. The system they believed was working. Probably, yeah, but maybe they were also upset too that he was just bonded out when he should have stayed behind bars. That no contact order, I mean, I don't know if we have a lot of faith in that. But as the weeks passed, that belief began to erode. According to family statements, the Spencers grew increasingly concerned that Fosler was continuing to contact their daughter despite the pending charges. Whether formal bond conditions included a no-contact order and whether any violations were reported or documented remains a key factual question that will likely emerge during Spencer's trial. What is clear is that the family's fear was real, visceral, and growing. Then on the night of October 8th, their worst nightmare returned. Their daughter didn't come home. Okay. So let's talk about the night of October 8th, the tracking, the confrontation, and the gunfire. So the timeline of that night, pieced together from news reports, court filings, and public statements, goes something like this. Early evening, Spencer's 14-year-old daughter left home. When she didn't return by the expected time, her parents began calling and texting. No response. As darkness fell, panic sets in. Heather Spencer called local authorities to report her daughter missing. Aaron Spencer, a father who had already seen his child victimized once and who believed the system had failed to fully protect her, wasn't willing to wait. He activated location tracking on his daughter's phone, technology many parents use for safety and peace of mind, and began following the GPS signal. So again, looks like he felt that she wasn't fully protected. I mean, you're letting this guy out who can try to make contact with her again. It was only a $50,000 bond. The signal led to a moving vehicle. According to Spencer's account, he tracked the phone to a pickup truck traveling on a rural highway in Lonoke County. He recognized the vehicle. He knew who was driving. It was Michael Fosler, the man charged with sexually exploiting his daughter, the man who was supposed to stay away, the man whose case was still pending in court. Now, Matt, who knows where he was going to go with her? I mean, he's getting ready to go to jail. How do we know he didn't pick her up and try to take off with her? We never see him again. Be a missing girl. The confrontation. Spencer forced the truck to stop. Accounts vary on exactly how, whether he blocked the road, pulled alongside, or used his own vehicle to physically stop Fosler's truck. What is undisputed is that both vehicles came to a halt on a remote stretch of highway, far from witnesses, security cameras, or immediate law enforcement presence. What happened in the next few moments is the crux of the entire case. Guys, he could have been taken off with her. I mean, think about it. He could be getting arrested, going to jail. He had nothing to lose here. Spencer's account. He approached the vehicle and found his daughter inside with Fosler. Believing she was in immediate danger of sexual assault or that an assault was already occurring or had just occurred, he confronted Fosler. According to defense narratives that have emerged in media reports, Spencer feared for his daughter's life and safety. In his mind, this was an active crime in progress, and every second mattered. He drew his firearm. There was a physical altercation or confrontation. Fosler made a move, whether aggressive, threatening, or defensive, depends on whose version you believe. Spencer fired multiple shots. I know we have the law. I get it, but at the end of the day, I think a lot of people will relate to the mindset of the father as well. So even if this wasn't active or in the moment, you have issues with my daughter. Now you're driving off with her, and you just blank. You just blank. I mean, at that point, it's not even just much about the moment, but I don't want you ever doing this again. This is the ultimate way I'm going to have to protect my daughter, is to stop the threat, and you're the threat. The state's theory. Prosecutors will argue that regardless of Spencer's fear or anger, the circumstances did not justify the use of deadly force. They will likely contend that Fosler was not armed, that he posed no imminent deadly threat, that Spencer had alternatives, calling 911, blocking the vehicle, physically restraining Fosler, and that the shooting was an act of retribution or rage, not lawful defense. The aftermath, Michael Fosler, 67 years old, died at the scene from gunshot wounds. Spencer called 911. When Lonoke County Sheriff deputies and Arkansas State Police troopers arrived, they found Fosler's body, Spencer's daughter physically unharmed but deeply traumatized, and Spencer himself, who reportedly did not resist arrest. He was taken into custody and charged with second-degree murder. His daughter was taken to a hospital for evaluation and later interviewed by forensic specialists trained in child sexual abuse cases. So we don't really know what was said there. That's going to be very important, though. The forensic details that will define the trial. So the physical evidence from that roadside confrontation will be dissected, analyzed, and argued over in very minute detail. Here's what both sides will focus on: ballistics and trajectory analysis. How many shots were fired? Was it a single shot in a moment of panic or multiple shots suggesting sustained intent? Sustained intent. What was the distance between Spencer and Fosler? Close range shots suggest a physical struggle or immediate threat. Distance suggests a more deliberate action. What was the angle of entry? Was Fosler facing Spencer, potentially advancing or threatening, or turned away, potentially retreating or trying to shield himself? And where were the wounds? Shots to the chest or head suggest lethal intent. Shots to extremities might suggest warning shots or a struggle for the weapon. Autopsy findings. The medical examiner's report will reveal cause of death, gunshot wounds to vital organs, and sanguination, so the bleeding out or other trauma, number and location of wounds, so entry and exit wounds, bullet paths through the body, defensive injuries, any evidence that Fosler raised his hands, tried to block the shots or fought back, and toxicology, whether Fosler had drugs or alcohol in his system that might have affected his behavior. Gunshot residue. Was GSR found on Fosler's hands or clothing? If so, it could suggest a struggle for the gun. If not, it supports the state's theory that Fosler never touched the weapon. The crime scene. Where was the daughter? Was she in the truck, outside the truck, restrained, free to move? Her physical position matters enormously. Where was Fosler's body found? Inside the vehicle, outside, near the driver's door, or farther away? Was there evidence of a struggle? Torn clothing, blood spatter patterns, disturbed ground damage to the vehicle? Was Fosler armed? If no weapon is found, the state's case strengthens. If even a knife or other object is found, the defense can argue Spencer faced a deadly threat. So there's a lot here. Sadly, it has to get to this point, but there's a lot here. The 911 call. News reports confirm Spencer called 911. That call will be critical evidence. When did he call? Before, during, or after the shooting? A call before suggests he was trying to get help and the situation escalated. A call after suggests the decision to shoot came first. What did he say? Was he panicked, asking for medical help for Fosler, explaining he just protected his daughter? Or was he calm, defensive, already crafting a narrative? And what could be heard in the background? Were there sounds of a struggle, the daughter crying, Fosler speaking or groaning? The legal framework. Why second-degree murder? Under Arkansas Code, I have subsection 5-10-103. A person commits second-degree murder if they knowingly cause the death of another person under circumstances manifesting extreme indifference to the value of human life. This is the heart of the state's case. So let's break it down. Knowingly. This is a mental state. Spencer must have been aware that his actions, firing a gun at another human being, will cause death or serious physical injury. This is not a high bar. The state doesn't have to prove Spencer wanted Fosler dead. That would be first-degree murder with premeditation. They only have to prove Spencer knew pulling the trigger would likely kill him. Unless Spencer argues the gun went off accidentally, which doesn't appear to be his defense, the knowingly element is virtually automatic. Extreme indifference to the value of human life. This is where the battle will be fought. The prosecution will argue that Spencer's action, confronting an unarmed man, escalating a situation that could have been handled by law enforcement, and using deadly force show extreme indifference. They'll paint a picture of a father who was so consumed by rage, fear, or frustration that he didn't care whether Fosler lived or died. Fosler. The defense will counter that Spencer's actions show the opposite of indifference. They show a father's desperate, immediate response to protect his child from what he reasonably believed was an ongoing sexual assault. They'll argue that the law expects parents to act when their children are in danger, and that hesitation could have meant the difference between rescue and further victimization. He stopped the threat. That's exactly what he did. He stopped the threat in so many different ways. Why not first-degree murder? First-degree murder in Arkansas requires premeditation, a decision made in advance with time to reflect and form intent. The state apparently concluded that Spencer acted impulsively in the heat of the moment upon finding his daughter with Fosler. That's second degree, intentional but not premeditated. And why not manslaughter? Manslaughter involves recklessness or heat of passion with adequate provocation. Prosecutors clearly believe Spencer's actions went beyond recklessness. They believe he knowingly used deadly force without justification, which makes it murder, not manslaughter. However, if the jury concludes the state proved an unlawful killing, but doesn't believe it rose to extreme indifference, they could convict on a lesser included offense of manslaughter. That would carry a lighter sentence, but still be a felony conviction. So much goes into these. Sometimes I feel they make it too complicated, but it's the rights of the people being accused. The justification defense, Arkansas law on deadly force. Spencer's entire defense rests on Arkansas Code subsection 52607, which allows the use of deadly physical force in defense of another person. Here's what the statute says. A person is justified in using deadly physical force upon another person if the person reasonably believes that the other person is committing or about to commit a felony involving force or violence, or using or about to use unlawful deadly physical force. Additionally, Arkansas law includes a specific provision for protection against sexual offenses. Under this framework, a person may use deadly force if they reasonably believe it is necessary to prevent kidnapping, rape, or sexual assault. What reasonable belief means? This is objective standard, not subjective. It's not enough for Spencer to say, I believe my daughter was in danger. The jury must conclude that a reasonable person in Spencer's position, knowing what he knew, seeing what he saw, would have believed deadly force was necessary. The defense will argue Spencer knew Fosler had been charged with sexually exploiting his daughter. That's important. His daughter was missing. She was found alone in Fosler's vehicle in violation of any reasonable understanding of appropriate conduct and possibly in violation of bond conditions. Fosler had no legitimate reason to be with her. Spencer saw his minor daughter in the truck of a man charged with grooming her, a situation that to any parent would look like an active sexual offense. Spencer reasonably believed his daughter was being sexually assaulted or was about to be. Could even been brought to another area, another state, where you'd never see her again. Every second mattered, and deadly force was the only way to immediately stop the harm. Could you imagine if he didn't find that vehicle? He would never have seen his daughter again. That's my opinion. What the state will argue, prosecutors will attack the reasonable belief element from multiple angles. They're going to say there was no imminent threat of deadly force. The statute allows deadly force to stop deadly force. The statute allows deadly force to stop deadly force or certain violent felonies. Was Fosler threatening Spencer or his daughter with deadly force? Did he have a weapon? Did he make threatening movements? If not, was deadly force justified, or should Spencer have used physical restraint, pepper spray, or simply blocked the vehicle and waited for police? Now, granted, remember, Spencer did have a weapon. So if Fosler was to come at him, and Fosler, let's say if he was a bigger guy or got the best of Spencer, Spencer would have could have had a chance of losing the weapon. So if you're coming at me, same thing with an officer, if you're coming at me and I have a gun, now there's a chance you could take the gun from me. That's why it's important. Also, they want to look to see if there was a struggle. Alternatives existed. Spencer had already called 911, or could have. Law enforcement was en route. He could have stayed on the phone with dispatchers, blocked Fosler's vehicle so he couldn't flee, ordered Fosler out of the truck at gunpoint and held him until deputies arrived, and used non-lethal force to subdue him. If any of those alternatives were viable, the prosecution will argue deadly force was not necessary and therefore not justified. The daughter was not in imminent danger. This is where the daughter's testimony becomes crucial. If she tells investigators and the jury that Fosler was not touching her, threatening her, or restraining her at the moment Spencer arrived, if she was sitting in the truck voluntarily, even if manipulated by grooming, the state can argue there was no imminent threat. Grooming is a crime. Being alone with a minor is a violation of court orders, is a crime, but neither automatically justify deadly force. And then you have emotion, not reason. The state will suggest Spencer acted out of rage, not reason. That he wasn't thinking about imminent harm. He was thinking about revenge for what Fosler had done to his family. That he saw an opportunity to permanently solve a problem that courts were taking too long to handle. That this was about punishment, not protection. The daughter's testimony, which I believe is the most critical and delicate evidence. So at the center of this case is a teenage girl who has already been victimized, first by Fosler's alleged grooming and now by being thrust into the spotlight of a murder trial. Her testimony will be the most powerful, most carefully litigated evidence in the case. What she might say. Was she restrained? Was she physically unable to leave, or was she there voluntarily, even if under psychological manipulation? Was she in distress? Was she crying, afraid, trying to escape, or was she calm, confused, or even defending Fosler, as grooming victims sometimes do? And we saw that, I think, a little bit with David, too, with the Celeste Rivas-Hernandez case, the defending. What was Fosler doing when Spencer arrived? Was he touching her, threatening her, driving away, sitting still? Did she want her father to intervene? Did she call for help, or was she trying to de-escalate the situation? Her answers to these questions will shape the jury's perception of whether Spencer's belief was reasonable and whether deadly force was necessary. I think part of the reason why they're moving forward with this could be what the daughter had said. Maybe. So that's going to be interesting what she said. The legal and ethical challenge. Both sides will fight over whether she testifies in person. The defense may want her live testimony to humanize the victim and corroborate Spencer's protective instincts. The prosecution may want to shield her from the trauma of courtroom, instead presenting her statements through forensic interviewers, or detectives. What the jury hears. So Spencer's team legally may have to cross-examine his own daughter. I'm just saying, hypothetically, we don't know, but he may want to protect his daughter and not have her go through the courtroom drama as well. But the lawyer may say, I know it's your daughter, but we're going to have to put her on the stand. So be ready for this. That's unique. That's complicated. What the jury hears, Arkansas has special rules for child victim testimony. Courts can allow closed-circuit TV testimony, limit cross-examination, and exclude the public during sensitive testimony. Both sides will argue over what protection applies. Because remember, the lawyers are going to do what's in the best interest for Spencer. So he may want to protect his family from this. So now they're going to be maybe a little debate there as well. But they may need that daughter's testimony matters if they're going to go this route. Both sides. Hearsay rules. If she doesn't testify, can her statements to investigators come in? Under Arkansas Rule of Evidence, excited utterances made under the stress of traumatic events can be admitted even if the speaker doesn't testify. Prosecutors may try to use this to get her initial statements in without subjecting her to cross-examination. Now, this is something I thought was unique. I didn't quite understand this gag order battle, free speech versus fair trial. So as national attention grew, so did concerns about pretrial publicity. In early 2025, the Lonoke County Circuit Court judge, facing a media frenzy, online fundraising campaigns, and intense public debate, issued a gag order, a legal restriction forbidding attorneys, witnesses, family members, and parties from speaking publicly about the case. Gag orders are rare and controversial. They sit at the intersection of two constitutional rights, the Sixth Amendment, which is the right to a fair trial, and the First Amendment, right to free speech. So why prosecutors wanted the gag order? From the state's perspective, the case had already become a circus. Every court filing was dissected online. Spencer supporters were holding rallies. Local news was running near daily updates. Social media was ablaze with opinions, threats, and conspiracy theories. Prosecutors argued that this constant commentary was prejudicing the jury pool. In a small county like Lonoke, where nearly everyone knows someone connected to the case, finding 12 impartial jurors was already going to be nearly impossible. Add in a media blitz and a GoFundMe campaign that had raised tens of thousands of dollars for Spencer's defense, and the risk of an unfair trial became, in their view, unacceptable. They cited Shepard versus Maxwell. And that's like in 1966. It was a landmark Supreme Court case where a murder conviction was overturned because pervasive media coverage made a fair trial impossible. The court in that case held that trial judges have a duty to control publicity that threatens the fairness of proceedings, and their gag orders, while disfavored, can be constitutional in extreme circumstances. The prosecution also argued that witnesses and potential jurors were being contacted, harassed, or influenced by online activists. A gag order, they said, was the only way to restore order and protect the integrity of the trial. Why the defense opposed it? Spencer's defense team fired back with a constitutional challenge, arguing the gag order was an unconstitutional prior restraint, a government order that stops speech before it happens. The U.S. Supreme Court has consistently held that prior restraint are the most serious and least tolerable infringement on First Amendment rights. And there's a Nebraska Press Association versus Stewart. They are presumptively unconstitutional. That happened in 1976. They are presumptively unconstitutional. It can only be upheld if there's a clear and present danger to trial fairness. No less restrictive alternatives exist. The order is narrowly tailored to address specific harms, and there are specific factual findings supporting the need for the restriction. The defense argued the gag order in Spencer's case failed every one of those tests. No clear and present danger, so media attention by itself doesn't prove bias. Jurors can be instructed to decide the case only on courtroom evidence. Voir dire, that's jury selection, can identify and remove biased jurors. A change of venue can move the trial to a less saturated community, and the state hadn't shown that these alternatives wouldn't work. Overbroad restrictions, so the order silenced not just Spencer and his lawyers, but also witnesses, family members, victim advocates, and even casual observers. It prohibited discussion of general legal principles, the facts of Fosler's prior case, and the public policy implications of the case, none of which directly threatened trial fairness. Then no factual findings. The trial judge hadn't identified any specific statements that caused jury bias. The order was based on speculation. This might prejudice jurors, not evidence that it had, and violate Spencer's rights as a defendant and as a political candidate. Spencer wasn't just a defendant. He was also, by this point, a declared candidate for sheriff. Silencing him meant silencing a political campaign. Courts have held that political speech receives the highest level of First Amendment protection. Gagging a candidate is an extraordinary intrusion that requires extraordinary justification. Explains why he ran for sheriff. Gave him a way to move around. That was a very smart move. Why the Arkansas Supreme Court struck it down? In Spencer versus State, the Arkansas Supreme Court sided with the defense and vacated the gag order. The court's reasoning was clear and sweeping. So he got that. He won that. Prior restraints require exceptional justification. The court reaffirmed that gag orders are disfavored and carry a heavy presumption against their constitutional validity. The state must show with specific evidence that intense and pervasive publicity exists. No other measures will ensure a fair trial, and the gag order will actually work to prevent prejudice. The trial court had not made any of those findings. It had issued a blanket order based on general concerns, not specific evidence. The order was not narrowly tailored. The gag order covered nearly everyone connected to the case: attorneys, parties, witnesses, investigators, victim advocates, and family members. It prohibited them from making any public statement related to the case, a restriction so broad it could encompass even factual, non-inflammatory statements or discussions of public interest. The Supreme Court noted that narrowly tailored orders might, for example, prohibit attorneys from making statements about inadmissible evidence or witness credibility, but they cannot silence all discussion of a case that has legitimate public interest. And then you got less restrictive alternatives were not considered. The trial court didn't explore other options. Careful voir dire, which is questioning potential jurors extensively about media exposure and bias. I mean, when I go on jury, they ask me what news you watch. Let's see your social media page. So they could weed that out. Jury instructions, directing jurors to decide the case only on evidence presented in court. Change of venue, moving the trial to a different county. And sequestering. So isolating juries during trial to prevent exposure to media. Any or all these could protect fairness without silencing speech. And the public's right to know. The court emphasized that the First Amendment protects not just the defendant's right to speak, but the public's right to receive information about how the justice system operates. In a case involving parental rights, child protection, alleged government failure, and a potential miscarriage of justice, depending on one's view, public debate is vital. Silencing that debate, the court said, risk eroding public confidence in the courts and suggest the judiciary has something to hide. The precedent it sets, Spencer versus State, is now binding precedent in Arkansas. It sends a clear message to trial judges. You cannot issue broad gag orders simply because the case is high profile or controversial. You must make specific findings, explore alternatives, and narrowly tailor any restriction. The ruling also reflects a broader national trend. In recent years, appellate courts across the country have struck down gag orders in high-profile cases, recognizing that in the age of social media, 24/7 news, and online activism, trying to silence discussion is both constitutionally suspect and practically futile. The consequences with the gag order lifted, Spencer, his family, his attorney, and his supporters were free to speak, and speak they did, leading directly to the next explosive chapter in this case, Spencer's run for sheriff. All right, so the sheriff race when a defendant becomes a candidate. So in October 2025, while awaiting trial for second-degree murder and still free on bond, Aaron Spencer announced he was running for Lonoke County Sheriff. His campaign slogan, restore trust, fix a broken system. It's powerful. It's connected to him, and people will see that connection. It's a very smart move. The announcement stunned legal observers, energized his supporters, and infuriated his critics. It also raised profound questions about the intersection of criminal justice, politics, and public opinion. So the legality. Can someone facing murder charge run for sheriff? Yes. Arkansas law does not prohibit someone under indictment from seeking elected office. The state constitution and election statutes disqualify convicted felons from holding office, but Spencer has not been convicted. Under the bedrock principle of American law, he is presumed innocent until proven guilty. If elected and later convicted, he would be removed from office. But until then, he has every legal right to run. So this may not even about him becoming the sheriff. This is about him getting his message out there. That's what this really is, I believe. The optics. Legally permissible doesn't mean politically or ethically uncomplicated. Spencer's campaign is built explicitly around his criminal case. His platform argues law enforcement failed his family. The sheriff's office and prosecutors didn't do enough to protect his daughter from Fosler, even after charges were filed. The system is broken. Predators like Fosler should never have been released on bond. No contact orders, if they existed, were not enforced, and families are left to fend for themselves. He will fix it. As Sheriff Spencer promises to prioritize child safety, aggressively enforce protective orders, and ensure no family suffers what he did. So, I mean, this is really it's a very smart move. As again, it's probably not even about winning sheriffs, it's about just putting his concerns out there. To his supporters, this message resonates deeply. They see a man who has lived the consequences of a broken system and who has the courage to step up and fix it. His campaign events draw hundreds. Yard signs bearing his name blanket the county. Church groups organize prayer vigils and fundraisers. On social media, Free Aaron Spencer trends regularly. To his critics, the campaign is a cynical attempt to manipulate public opinion and prejudice the jury pool. They argue Spencer is using his platform to portray himself as a victim rather than an offended, frame his actions as heroic rather than criminal, influence potential jurors by conflating political messaging with legal defense, and turn his trial into a referendum on law enforcement rather than an objective assessment of whether he committed murder. So the jury selection problem. So this is one concern that on the Ashley Banfield, you saw also the judge say it is the practical impact on jury selection is enormous. In a county where nearly everyone has heard of the case, voir dire was already going to be a grueling process. Now with Spencer's face on campaign signs, his name on ballots, and his messaging explicitly tied to the facts of his case, how do you find 12 people who can set aside everything they've heard and decide the case purely on courtroom evidence? And then you got your defense perspective. Public publicity, even intense publicity, doesn't automatically equal bias. The solution is thorough, voir dire, asking potential jurors detailed questions about what they've heard, what they believe, and whether they can be fair. Jurors who admit bias are dismissed. Those who remain are instructed by the judge to decide only on evidence. And I like that because sometimes it's like, oh, we got to hide the truth so they can't be biased. No, you're making it sound like we are just so easily influenced that we sway. That's not the case. We could sit there reasonably and decide as the evidence comes. So I think sometimes people hide under that saying, well, if we release too much, it's going to bias everyone. No, we can eliminate influence and look at the evidence. Prosecution perspective. At some point, saturation becomes so complete that an impartial jury is impossible. When the defendant is a political candidate whose platform defends the very act he's charged with, and when voters are being asked to endorse their platform, the line between political campaign and jury tampering blurs. The change of venues motion. So given the saturation of publicity and the political dimension of Spencer's campaign, prosecutors are expected to file a motion for change of venue, asking the court to move the trial to a different Arkansas county where the jury's pool is less exposed to the case. Under Arkansas law, a defendant is entitled to a trial by an impartial jury. If pretrial publicity has so saturated the community that impartiality is impossible, the court must grant a venue change. Factors courts consider: the extent and nature of media coverage, whether coverage was factual or inflammatory, the size and demographic of the community, whether voir dire can identify unbiased juries, and whether a continuance delay would reduce publicity. Spencer's case, the coverage has been intense, ongoing, and deeply polarizing. A venue change is likely, but not certain. If granted, the trial would move to another Arkansas county where jury selection would start fresh. And then you have the evidentiary battles to come. Before the jury ever hears opening statements, both sides will wage war over what evidence gets admitted. So here are some of the key battlegrounds. I thought this was unique. These are the things that are kind of being discussed as what can be admitted, what can't be admitted. So Fosler's prior charges and criminal history. Defense's position, the jury must know about Fosler's pending sex crime charges. It's not about character assassination. It's about explaining Spencer's state of mind. Why did he believe his daughter was in immediate danger? Because Fosler had already been charged with grooming her. Why did he believe deadly force was necessary? Because he knew Fosler was a sexual predator who had victimized his child before. Without this context, the jury sees only a father who shot an unarmed 67-year-old man. With it, they see a father who confronted a charged sex offender found alone with his minor daughter. Prosecution's position, this is classic Rule 404B evidence, using prior bad acts to suggest Fosler was a bad person who deserved what he got. The rule explicitly prohibits using evidence of other crimes to prove someone's act in conformity with their character. The risk of unfair prejudice is enormous. If the jury hears child predator, they may conclude Fosler deserved to die, regardless of whether Spencer's use of force was legally justified. The trial becomes about punishing Fosler rather than determining whether Spencer committed murder. The likely ruling, the court will allow some reference to charges, enough for the jury to understand Spencer's knowledge and mindset, but will limit the details. The judge might allow testimony that Spencer knew Fosler had been charged with crimes involving his daughter, but prohibit reading the actual charges, discussing evidence from that case, or characterizing Fosler as a predator or monster. The judge will also give a limiting instruction, telling jurors they may consider the evidence only for the limited purpose of understanding Spencer's state of mind, not to conclude Fosler was a bad person who deserved to be killed. And then you have the forensic and autopsy evidence. This evidence is almost certainly coming in. The questions are how it's presented and what story it tells. So the ballistics, how many shots, from what distance, at what angle. The autopsy, where did bullets strike? Were there defensive wounds? Was Fosler facing Spencer or turned away? Gunshot residue, was GSR found on Fosler? If yes, it suggests a struggle for the gun. If no, it suggests Fosler never touched it. And blood spatter analysis, can investigators reconstruct positions and movements? Both sides will hire expert witnesses to interpret this evidence. The defense will emphasize any evidence suggesting a threat or struggle, and the prosecution will emphasize evidence suggesting Fosler was unarmed, not advancing, and posed no deadly threat. And the daughter's testimony. This is the most sensitive and most critical evidence. Several legal issues will be fought over. So competency, is she competent to testify? Given her age and trauma, can she accurately recall and relate what happened? Arkansas law presumes children over age 10 are competent, but the court can hold a hearing if there's questions. Hearsay, if she doesn't testify in person, can her statements to investigators be admitted? Possible exceptions. Excited utterances. A statement made under the stress of an exciting event before time to reflect or fabricate. Statement for medical diagnosis. Statements made to medical personnel for diagnosis or treatment. And residual hearsay exceptions for statements with equivalent guarantees of trustworthiness. Manner of testimony. If she does testify, the defense may request closed-circuit TV testimony, allowing her to testify from another room with her image shown to the jury on a screen. And that could be allowed under the Arkansas Code, and that's also for child victims of sexual offenses. Cleared courtroom, excluding the public and media during the testimony, and limits on cross-examination, restricting questions about her sexual history, grooming, or other traumatic details. And that's going to be unique in where you have the defendant versus the father versus the prosecution. Three things there. Spencer's statement. Every word Spencer said from the moment deputies arrived to his public campaign speeches is potential evidence. Statement at the scene. What did he tell deputies? Did he claim self-defense immediately, or did his story evolve? 911 call. What did he say and when? Was he seeking help for Fosler or only explaining his actions? Interviews with investigators. Did he voluntarily speak with detectives? What did he admit or deny? And social media and campaign statements. Has he made statements that contradict his legal defense or show consciousness of guilt? The prosecution will comb through these for inconsistencies or admissions. The defense will try to show consistency and a genuine belief that he was protecting his daughter. And then you have the character evidence. The defense may try to introduce evidence of Spencer's good character, his military service, his reputation in the community, his lack of prior criminal history. And under Rule 404A1, a defendant can introduce evidence of a pertinent character trait like peacefulness or lawfulness to suggest he didn't commit the charged crime. The prosecution can rebut with evidence of bad character, but only if the defense opens the door first. What we still don't know, despite months of litigation and media coverage, key facts remain unknown or sealed. the complete investigative file, the full police reports, witness statements, crime scene photos, forensic analysis, and investigator notes are in the case file but not publicly released. Until defense and prosecution completes discovery, the public record remains incomplete. Then you have the bond conditions in Fosler's case. Did the court impose a no-contact order when Fosler bonded out after his July 2024 arrest? We believe so. I've seen it, but I just can't verify it. So you guys may know more, but I believe there was a no-contact order. What were the specific conditions of his release? That's we may not know. Were there any documented violations before October 8th? I don't think we know that yet. But I heard, and that's why I put it in there, that there were concerns. These details are in Fosler's case file and will be critical understanding whether the system failed the Spencer family or whether their perception of failure was based on incomplete information. And prior complaints and law enforcement responses. Spencer said they warned authorities that Fosler was continuing to contact their daughter despite his pending charges. Were these warnings documented in police reports? Did they file formal complaints? Did prosecutors or victims advocates respond? How did law enforcement investigate these alleged violations? This is a factual dispute that will significantly impact both public perception and the jury's view of Spencer's actions. If documented complaints exist showing the system ignored repeated warnings, Spencer's defense strengthens considerably. If such documentation doesn't exist, prosecutors can argue Spencer's fear was based on speculation rather than evidence of ongoing danger. And then you got the daughter's complete account. What exactly did Spencer's daughter tell forensic interviewers in the hours and days after the shooting? Her initial statements made before media coverage, before family discussions, before she understood the full implications are likely the most reliable evidence of what actually happened that night. Those statements are protected under victim privacy laws and won't be publicly released before trial, but they will be the most fought after evidence in the case, fought over evidence. So again, what she said before, because then they could say, well, she could have been manipulated by the family later. So what she said before will carry a lot of weight, and I'm sure they'll argue what they say later may not. Fosler's autopsy report. While we know Fosler died from gunshot wounds, the complete autopsy report detailing the number of wounds, their location, angles of entry, trajectory paths, and whether they were anywhere immediately fatal remain sealed. This report will become central to both sides, theories of what happened in those final moments. So it will become a central to both sides' theories of what happened in those final moments. Spencer's ballistics and use of force analysis. Did investigators conduct a ballistic reconstruction? Did they bring in use of force experts, analyze whether Spencer's actions were consistent with a defensive response or an offensive attack? Did they test for gunshot residue on both Spencer and Fosler? And these analyses, if completed, remain confidential. And trial date and venue decision. As of late 2025, no firm trial date has been set. Pre-trial motions are ongoing. A change of venue motion is expected but not yet ruled on. And whether the trial occurs in Lonoke County or elsewhere and when it begins remains uncertain. The delay benefits the defense in some way. It allows passions to cool, memories to fade, and media attention to shift elsewhere, but it also prolongs the uncertainty for Spencer's family, the community, and the memory of Michael Fosler. So what's the missing pieces? What does Fosler's family have to say? One voice largely absent from the public narratives is Michael Fosler's family. While Spencer's supporters have been vocal and organized, Fosler's relatives have remained largely silent. This isn't unusual. Families of those killed often retreat from public view, grieving privately while this legal system works its way out. But that silence creates an imbalance in public perception. We hear constantly about Spencer's children, his military service, his role as a father. We hear little about who Michael Fosler was beyond the charges against him. Was he a grandfather? Did he have children of his own? What was his life before the allegations? Did he have his own family, or who now grieves his death? These questions matter because the law and justice require us to see Fosler as a full human being and not merely as the charges against him. Even if those charges were true, even if he committed the acts alleged, he was still entitled to due process, a trial, and the presumption of innocence. He was entitled not to be killed on a highway by a private citizen acting as judge, jury, and executioner. That's the prosecution's core argument. And it's why Fosler's humanity matters in this case. The state isn't defending child predation. It's defending the principle that no one, no matter how despicable their alleged acts, can summarily executed without trial. And guys, that's just what the prosecution is going to put. I try to put stuff that's objective, whether we agree or not. That's going to be an angle. The broader legal and social questions. The Spencer case forces us to confront uncomfortable questions that extend far beyond one Arkansas highway. So when does parental protection become vigilantism? When does parental protection become someone being a vigilante? Every parent understands the visceral instinct to protect a child. If you found your son or daughter in the hands of someone you believe meant them harm, what would you do and how far would you go? The law draws a line. You can use force, including deadly force, when it's immediately necessary to stop imminent harm, but you cannot use the legal system's failures, your justified anger, or your moral certainty as license to bypass law enforcement and impose your own punishment. Spencer's case tests that line. If his daughter was actively being assaulted, if Fosler was touching her, restraining her, threatening her in that moment, then deadly force may have been justified. But if she was simply in the truck, even if she shouldn't have been there, even if Fosler's presence violated court orders or moral boundaries, does that justify killing him? What obligations do law enforcement and courts have? If the Spencer family's account is accurate, if they repeatedly warned authorities that a charged sex offender was continuing to contact their minor daughter, and if those warnings were ignored or inaccurately addressed, then the system failed catastrophically. Bond conditions exist precisely to prevent this. No contact orders exist to protect victims. Prosecutors and victim advocates exist to ensure victims' voices are heard and safety is prioritized. If all of that broke down, then Spencer's actions, while perhaps not legally justified, become morally understandable. The case raises hard questions for law enforcement. How are bonds conditions monitored and enforced? What happens when victims report violations? Are there sufficient resources for victim advocates and monitoring? And do judges take violations seriously enough? If Spencer is acquitted, one interpretation will be that the jury believed the system failed so badly that a father had no choice but to take matters into his own hands. That would be a damning indictment of the criminal justice system's ability to protect vulnerable children. Can we separate our feelings about Fosler from legal questions? This is perhaps the hardest question of all. Michael Fosler was charged with reprehensible crimes against a child. If those charges were true, he deserved to face justice, conviction, imprisonment, registration as a sex offender, and societal condemnation. But he also deserved a trial. He deserved the chance to confront his accusers, present a defense, and have guilt or innocence determined by a jury. That's the bedrock of American justice. No punishment without due process. When we cheer Spencer's actions, when we say he got what he deserved, when we argue that a parent has the right to kill someone who victimized their child, we're saying due process doesn't matter, that some people are so lonesome they forfeit their right to fair trial. That's a dangerous road, because once we accept that principle, who decides who deserves due process and who doesn't? Who decides when someone is evil enough that killing them is justified? Do we trust every parent to make that determination correctly? What happens when someone gets it wrong? These aren't abstract questions. They're the moral core of the Spencer case. That's why they have to go for self-defense, reasonable belief. And I said in my case here, I've been driving around outstate. I just have to protect my child ultimately. And at this point, I would push on the system. The cultural and political divide. The Aaron Spencer case has become a proxy battle in American broader cultural wars. For conservatives in rural communities, Spencer represents parental rights, the fundamental right and duty of parents to protect their children, even when it means defying or bypassing government institution. I wonder how that plays out with the Ashley Buzzer case when you look at this, how strong that right is. Distrust of institutions, a belief that court, law enforcement, and bureaucracies are too slow, too lenient, and too disconnected from the realities of protecting families. And traditional masculinity and fatherhood, the ideal of a father as a protector and provider, willing to do whatever it takes, including violence, to keep his family safe. Second Amendment values, the belief that armed citizens have the right and responsibility to defend themselves and their loved ones when government fails, and accountability for predators, frustration with the system seen as coddling criminals while victims suffer. For progressive and criminal justice reformers, Spencer represents, that's the other side, vigilantism, being a vigilante, the dangerous breakdowns of rule of law when individuals take justice into their own hands, gun violence, another example of how easy access to firearms enable lethal responses to situations that could be resolved non-lethally. And again, this is the other side. Due process violations, the principle that even accused criminals deserve trials, not extrajudicial executions, and racial disparities, questions about whether a black father who killed a white man under similar circumstances would receive the same community support and prosecutorial treatment, though both Spencer and Fosler were white. The broader question of unequal justice remains, because that's also part of the argument. Toxic masculinity, the glorification of violence as a solution to conflict rather than patience, dialogue, and trust in institutions. So guys, I'm just saying that's out there. That's trying to cover both sides. I have my perspective, which I gave at the beginning. National media coverage has amplified these divisions. Conservative outlets frame Spencer as a hero and martyr. Progressive outlets emphasize the rule of law and the dangers of being a vigilante. Social media algorithms push users towards content that confirms their existing beliefs, creating echo chambers where Spencer is either a saint or a murderer with little room for nuance. The result is a case where facts matter less than tribal allegiance. Supporters and opponents often know little about the actual evidence. They simply know whose side they are on. That's powerful. So again, we have to wait for that evidence. Maybe there's more that hasn't been said. But with that said, I could see myself acting just because of the background and where we're at now. You're in the vehicle again, and just the frustration, but doesn't make it right. I mean, but I think a reasonable, like she said before, the nullification. I think I wouldn't, because in the moment, I if I was a juror, I wouldn't convict him. Just being a father, and probably I may do that myself. What happens next? The trial timeline and possible outcomes. As the case moves forward towards trial, here's what to expect. Pre-trial phases, that's ongoing. Motions practice. Both sides will continue filing motions to exclude evidence, compel discoveries, change venue, and shape the trial parameters. These motions can take months to litigate. Then you got the discovery. The defense is entitled to review all evidence the prosecution has, police reports, witness statements, forensic analysis, and anything potentially exculpatory, favorable to the defense. Prosecutors are simultaneously reviewing the defense evidence and expert reports. Plea negotiations, although Spencer has publicly committed to fighting the charges, behind-the-scene plea negotiations are common. The prosecution might offer a reduced charge, like manslaughter instead of murder, in exchange for a guilty plea that avoids the uncertainty of trial. Whether Spencer would accept such a deal is unknown, but given his public posture and sheriff's campaign, a plea seems unlikely. He looks like he's going to fight this out. And jury consultant and change of venue. If the venue stays in Lonoke County, both sides will likely hire jury consultants to analyze the community, identify demographic factors that correlate with favorable jurors, and develop voir dire strategies. If venue changes, that process starts fresh in the new county. Trial phase expected in 2025. Jury selection could take days or even weeks. Attorneys will question hundreds of potential jurors about their knowledge of the case, their views of parental rights and self-defense, their feelings about law enforcement, and their ability to be impartial. Both sides have unlimited for-cause strikes, removing jurors who admit bias, and a limited number of preemptory strikes, removing jurors for any reason except race or gender. Opening statements, prosecutors will lay out their theory. Spencer knowingly killed Fosler without legal justification, motivated by anger or revenge, rather than imminent necessity. The defense will counter. Spencer acted as any reasonable parent would to stop an ongoing sexual assault of his child, or the future sexual assault of his child. State case in chief. Prosecutors call witnesses and introduce evidence to prove beyond a reasonable doubt that Spencer committed second-degree murder. Expect law enforcement officers who responded to the scene, crime scene investigators and forensic experts, the medical examiner who performed Fosler's autopsy, possibly Spencer's daughter, the most impactful and controversial witness, ballistics and firearm experts, and digital forensic experts who can establish timeline and locations. Defense case. After the state rests, the defense presents its case. Expect Spencer himself. Defendants are not required to testify, but given his public stance, he likely will. Character witnesses attesting to Spencer's reputation in military service. Use of force experts who will testify that Spencer's actions were reasonable. Possibly mental health experts discussing the psychological impact of knowing one's child is being victimized. And rebuttal witnesses to challenge the state's forensic interpretations. As for closing arguments, each side gets to summarize the evidence and argue why the jury should find for their side. Prosecutors have the final word. They get to argue. Then the defense argues. Then prosecutors get the rebuttal. Jury instruction. The judge instructs jurors on the law, what elements the state must prove, what the justification defense requires, and what reasonable doubt means, and how to deliberate. Deliberation. The jury's retired to deliberate in private. They can take hours, days, or even weeks. They must reach an unanimous verdict and possible verdicts. We got guilty of a second-degree murder. Spencer faces 10 to 30 years or life in prison under Arkansas law. Firearm enhancement could add additional time. He'd be immediately taken into custody. His sheriff's campaign would end. His family would be shattered. Appeals would follow, but convictions are rarely overturned on appeal, absent significant legal error. Then you have guilty of a lesser included offense. That's manslaughter. If jurors believe Spencer killed Fosler unlawfully, but don't find extreme indifference to human life, they can convict him on a lesser charge of manslaughter. This carries a lighter sentence, typically 3 to 10 years, though it varies by circumstances. Spencer would still go to prison, but for less time. And again, no chance to be sheriff. Not guilty. Spencer walks free immediately. He cannot be retried. Double jeopardy protects against that. He returns to his family, continues the sheriff campaign, and likely becomes a national figure in the parental rights and Second Amendment movements. The acquittal would be seen by supporters as vindication and by critics as miscarriage of justice. And then you have the hung jury. If jurors cannot reach a unanimous verdict, the judge declares a mistrial. The prosecution can choose to retry the case with a new jury, drop the charges, or offer a plea deal. A hung jury is emotionally and financially exhausting for all involved and often leads to plea negotiations. And then post-trial, if convicted, Spencer's attorney will file appeals, arguing legal errors, improper jury instruction, wrongly omitted or excluded evidence, prosecutorial misconduct, or insufficient evidence. Appeals can take years. Spencer would remain incarcerated during the process unless granted bail pending appeal, rare in murder convictions. And if acquitted, the criminal case ends, but civil litigation could follow. Fosler's family could file a wrongful death lawsuit against Spencer seeking monetary damages. The standard of proof in civil cases is lower, preponderance of evidence rather than beyond reasonable doubt. So Spencer could be found civilly liable even after a criminal acquittal. However, given Fosler's pending criminal charges and public perception, such a lawsuit would be legally and politically fraught. And the legacy of Aaron Spencer's case, regardless of the verdict, this case will leave a lasting mark on Arkansas's law, American culture, and the ongoing debate over parental self-defense and vigilante justice. The legal precedent: if Spencer is acquitted, defense attorneys across the country will cite this case when arguing justification defenses in similar situations. They'll say a jury in Arkansas found that a father was justified in using deadly force to protect his child from a charged sex offender becomes a powerful theoretical tool, even though jury verdicts don't create binding legal precedents. If convicted, prosecutors will point to the case as proof that the law does not permit parents to take lethal action based on fear alone, that even the most sympathetic facts don't override the requirement that deadly force be immediately necessary. And the Arkansas Supreme Court gag order ruling in Spencer v. State is already binding precedent and will shape how Arkansas judges handle publicity in future high-profile cases. Cultural impact: the case has already inspired countless debates, sermons, opinions, pieces, and social media arguments about the limits of parental authority, whether the criminal justice system adequately protects children, the role of firearms in self-defense, whether stand your ground and defense of other laws go too far or not far enough, and how we balance empathy for victims with due process for the accused. Spencer has become a folk hero in some circles and a cautionary tale in others. His story will be told and retold, adapted and mythologized, mythical, long after the trial ends. So in the political ramifications, if Spencer wins his sheriff race either before trial or if it's delayed or after an acquittal, he becomes one of the most unusual elected officials in America, a sheriff who killed someone while protecting his daughter and was vindicated by both the jury and the voters. His tenure would be closely watched. Would he reform the system as promised? Would he face legal or political challenges? Would he become a model for other outsiders, candidates running on platforms for protecting families when government fails? If he loses the election or if he's convicted before it occurs, his campaign still serves as a powerful statement about public sentiment and the depth of distrust many Americans feel towards institutions. So the conclusion, a question with no easy answers. The Aaron Spencer story is ultimately about a father, a daughter, a deadly decision, and a legal system trying to determine whether that decision was justified. It's about the tension between our instinct to protect and our obligation to follow the law. It's about what we owe the victim. It's about what we owe to victims, what we owe to the accused, and what we owe to the principle that justice must be determined by courts, not by individuals with guns. Again, just putting it out there. That's how it's viewed. It's about whether a broken system can be fixed from within or whether sometimes people have no choice but to act outside it. Aaron Spencer says he saved his daughter's life. Prosecutors say he took a man's life without justification. 12 jurors will decide who's right. But whatever they decide, the question this case raises is, it's about justice, morality, parental love, and the rule of law will linger long after the verdict is read. I'm going to read that last paragraph again. But whatever they decide, the questions this case raises about justice, morality, parental love, and the rule of law will linger long after the verdict is read. Guys, there was a lot there to cover. Woof! But hopefully it just gives you a lot of information. So when you watch the case unfold, you kind of see where things are going, see what they try to do. You kind of get a better understanding of both sides, because as I read it, I get myself more informed. So this is great. I'm learning as we go. Eventually, as the channel gets, bigger and bigger, I will probably be able to get better guests who can do a little bit more of this research for me. That would be very helpful. But as always, guys, if you like the content, please, I have Buy Me a Coffee. It's in a link in the description as well as up on top of my homepage. And as always, guys, stay safe.